Welcome to the Applied Legal Research Microcertificate for Administrative Materials. My name is Kristen Baginski, and I will be your instructor for this module. I'm currently the Lexis Practice Area Specialist covering intellectual property and data security and privacy law on the National Practice Area team. Previously, I was a Lexis Law School rep covering Duquesne Klein, the University of Pittsburgh, and the University of West Virginia Schools of Law. Additionally, my legal background includes being an adjunct professor where I taught LR&W. I was also a faculty librarian where I taught introductory and advanced legal research, and I spent time as a law firm librarian. If you have any questions about this module or about administrative law in general, you can reach out and contact me at the email that you see on your screen. Our learning objectives for this legal research microcertificate in administrative materials are as follows. We want to identify and find relevant administrative law materials, including administrative codes and regulations, as well as agency material. The skills we'll use for this are search term engineering and effective filter application. We also want to understand the difference between binding and advisory administrative authority. The skills for this will be authority review. So why admin law? Administrative law involves the administration and regulation of federal and state government agencies. Statutes create laws, and administrative rules, regulations, decisions, and guidance help carry out the specifics of those laws. Federal agencies are created through federal law via enabling legislation. Administrative law sources will consist of rules, regulations, and agency decisions promulgated by administrative agencies. Regulations have the same force as statutory law. It's important to know regulations are very dense and prolific. To learn more about finding administrative law, let's use the following hypo. Taystar Toy Co. is a family-run conglomerate of the toy family with business in various industries, including cosmetics. The daughter of the patriarch, Liv Toy, runs the cosmetics branch of the company. The firm you work for represents Taystar Toy Co.'s intellectual property holdings. Liv's team has created several new fragrances, and Taystar Toy Co. would like to apply for patents for the perfume compositions. The partner you work for has let you know that you'll be working with the team on the patent prosecution, so you need to be ready to practice at the USPTO. So what's next? You need to determine if you can practice in front of the USPTO, the United States Patent and Trademark Office, which is a federal agency. What is the best way to find regulations? You can start in the CFR, which we'll learn more about later, or you can find the enabling legislation via statute. Either way, you're going to need good search terms. To determine search terms, it's best to organize your research. Go through the hypo. Go through your client's issues. Go through the issues in front of you. In this situation, the search terms we're going to use are going to be practice and USPTO. Remember, regulations are dense and prolific, so it's often easier to start with enabling legislation. To start your research with a federal statute, it's pretty easy. You can click on statutes from Explore Content, or you can type USCS into the search bar and the US code will auto-populate. You can do a quick terms and connector search in the table of contents for the US code for practice in USPTO. Once you run this search, you're going to want to look at your results list and make some value judgments about what you see. The first statute section in the results list, suspension or exclusion from practice, seems maybe not completely on topic. But if you dig a little deeper, you see that this section is part of a larger code section dealing with practice before the Patent and Trademark Office, which of course is directly on point. So go ahead and click the link for 35 USCS section 32. suspension or exclusion from practice to see if this code section is helpful to our overall issue of practice before the USPTO. If we read through the statute, we do learn some useful information about practice before the USPTO, and we learn what can get you excluded from practice. We even get a mention of regulations and a hyperlink to the statute section that created regulations. It's worth looking at this hyperlink statute section, so go ahead and click the hyperlink, easily get to the full text. As we read through this new code section, we start to learn more about what is needed to practice in front of the USPTO. Again, we get a reference to regulations. The office may establish regulations. This is what would be known as an enabling statute. The statute that gives the agency or agency director the authority to carry out rules called regulations. But what are the regulations? Who can practice in front of the USPTO? Who does the USPTO consider to be a practitioner? A great part of online research are the embedded tools and value adds. Using the navigation pane for the statute, you can quickly jump to the statute's research references and practice aids. In this section of the statute, you will find, among other tools, a list of relevant regulations with hyperlinks to the relevant CFR sections. Before jumping into the regulations themselves, it's worth taking a minute to discuss federal regulations generally. Federal regulations are published in the Code of Federal Regulations, but first, they exist in the Federal Register. The Federal Register is a daily gazette that features, among other things, new and newly amended federal regulations. Once the regulations are approved, they're published in the Code of Federal Regulations, which presents the official and complete text of agency regulations in an organized fashion in a single publication. The CFR is divided into 50 titles, covering broad subject areas of federal regulations. Title 37 is the CFR title on point for our issue. You can start your research with the CFR. And to do that, you can again go to Explore Content, click on Administrative Codes. From there, you can also go back to the home screen. You can type CFR into the search bar. And like we've seen before, click on the link. You can search the table of contents. Here we can put in USPTO as our search term. But again, remember, regulations are dense and prolific. There is a lot to wade through, and that's why it's better to start in your enabling legislation. So let's get back to our statute. We were in US Code 35, USCS Section 2. We see several regulations here, and that seemed useful. One of those, representation of others before the United States Patent and Trademark Office, Section 37 CFR 11.1 EXEC, seems directly on point. Also relevant to note that when you see EXEC, this is a term that means and the following, and it lets you know there are multiple regulations. We click on the hyperlink for 37 CFR 11.1. We can quickly jump into the full text of the regulation and finally learn what's needed to practice before the PTO. Once you're finally in the regulation, there are several steps to get in the habit of doing. You want to note the date. You want to read through the regulations. Also, you're going to want to open the table of contents in the regulation so that you can see what other related regulations are available. Next, you want to use the navigation pane to look at other relevant parts of the regulation. Use the search term map to see where your search terms populate in the regulation and direct your closest reading there. Again, like in the statute, you will find history. You can see where your regulation started in the Federal Register, and you'll also find research references and practice aids. You might find sources here to help you better understand the regulation. It's important to know if your regulation is current and how to interpret your regulation. There's a very easy way to do this, and that is via Shepard's. Shepard's is a citator. In fact, it's the gold standard of citators used by legal professionals for over 150 years. Here you can use that to make sure the regulation is still good law, but also to help you find cases and other materials to interpret. In the Shepard's report, you'll see case opinions would tell you if a court has criticized the regulation, in addition to opinions citing to or interpreting the regulation, which are very helpful in determining how the regulations have been applied in other situations. Additionally, in the Shepard's report and the other citing sources, you'll get helpful resources where the regulation has been cited or discussed, including secondary sources, court documents, annotated statutes, and in some cases, you may even come across other related regulations. The Shepard's report also helps you determine if your regulation is up to date. There will be updates in the pending and adopted tool in Shepard's. However, to complete your due diligence, you also need to check the Federal Register. It's easy to check the Federal Register. From the search box, again, you're going to type in Federal Register, click the link, and open the landing page for the list of all Federal Registers going back to 1936. You only need the most recent version, so click on the link for the current year and month and type in the regulation number here, 11.1. When you get your results, you want to sort them by date and determine if your regulation is current. If your regulation, here again, 11.1, shows up in the Federal Register, take into account whatever is amended while you interpret the regulations. It's easy to find agency materials. In addition to regulations, administrative law also encompasses relevant administrative agency materials. These resources can include policy statements, compliance guidance, opinion letters, and other material to help you and your clients. Most federal regulatory agencies possess both adjudicatory and rulemaking powers. Rulemaking, the quasi-legislative power, is intended to add substance to the acts of Congress to complete absent but necessary details and to resolve unexpected problems. Adjudication, the quasi-judicial power, is intended to provide for the enforcement of agency statutes and regulations on a case-by-case basis. Although the Administrative Procedures Act supports the impression that rulemaking and adjudicatory proceedings have distinct functions, there's much common ground between both actions. Agencies often use their adjudicatory powers to issue both retroactive and prospective orders, which for all intents and purposes must be considered rules. Since agencies conduct a large number of adjudicatory proceedings, the rulemaking proceedings, it follows that many prospective rules may be issued during adjudications. In addition, the courts maintain the position that rulemaking during adjudicatory proceedings is a necessary corollary to the administrative quasi-judicial function. So, is there any other guidance for practice before the Patent and Trademark Office? If you do practice before the USPTO, what kind of decisions are made? It's easy to find agency materials. You can quickly find relevant agency decisions about practice in front of the PTO from the search box, again running our search for practice in USPTO. To find agency decisions, filter your category to administrative materials. Don't confuse this with administrative codes. It's not the same as administrative materials. The USPTO is created by the Department of Commerce. So when you look at agencies, you'll find the USPTO under the USDOC agency. Here, you'll find decisions by administrative law judge and other information. For example, here you see comments from the notice and comment period about a law that happens before regulation is promulgated. In this specific instance, we can also find information about adjudications, letting people know that they're no longer allowed to practice in front of the USPTO. There are also a variety of other agency materials promulgated by the USPTO. If we look at our client's issue, patenting of a perfume fragrance, we might also want to know, is it easy to get such a patent? Where does practicing in front of the USPTO come into play in this patent application process? Why am I even going to be needed to practice at the USPTO? It's important to know that as you apply for patents, you will very likely have to argue to the USPTO via the Patent Trial and Appeal Board, otherwise known as the PTAB. When that happens, the PTAB can issue a decision and helps justify whether or not your patent can be granted. You can then find these cases in administrative materials. The PTAB is tasked with the following duties. On written appeal of an applicant, review adverse decisions of examiners upon applications for patents. They review appeals of reexaminations of patents. They conduct derivation proceedings and conduct inter-partes review and post-grant reviews. Again, it's not that hard to find agency materials. You can come to your search box and type in perfume, fragrance, click search. Again, you'll want to filter to administrative materials, choose the USPTO via the Department of Commerce, and there you will see PTAB decisions. Then you can read how the PTAB decided whether to grant patents on your particular patent topic. One important note about agency decisions. You will want to be sure to research the agency to determine if and when opinions or decisions of issues before the agency are binding and precedential or simply informational or possibly somewhere in between. For the PTAB, decisions have one of four designations. They're either precedential, informative, representative, or routine. Where precedential is considered binding, but routine is not binding authority, and every PTAB opinion is, by default, a routine opinion until it's designated otherwise. Such opinions have very little persuasive value in relation to other PTAB opinions in other cases. Routine opinions typically turn on the specific facts of the case, and most PTAB decisions are routine. An agency's webpage can usually direct you to the types of decisions an agency may give. And when you read an agency decision, use that navigation pane to find the notice in the decision to learn what type of opinion you're looking at. So what have you learned in this micro certificate for administrative materials? Based on what was uncovered in this administrative search, it looks like you can practice in front of the PTO, and now you even have an idea of what the agency does. To arrive at this conclusion, you found relevant enabling legislation for USPTO practice, used the statute to find relevant regulations, made sure your regulations were current, found additional agency material, and determined whether your agency decision was binding authority. So to recap, what did we learn in this administrative materials micro certificate? You learned how to identify and find relevant administrative law materials, including administrative codes and regulations, as well as agency material. For this, we used search term engineering and effective filter application. We also now understand the difference between binding and advisory administrative authority, and for that, we did an authority review. Upon successful completion of the administrative materials quiz, you will receive your micro certificate. You are eligible to earn an applied micro certificate in secondary sources, case law, statutory law, and administrative materials. Earn all four and showcase your diverse legal research skills. Thank you for your participation in this micro certification program. Best of luck in all your future legal endeavors.